Good morning. I'm Jayashree. Welcome to iOS Judicial Services Coaching. Today we will continue with section 92. We had left it. We had just read the first subsection number 1. We will do with subsection. We'll start with subsection number 2. Okay. Save as provided. What was the heading of section 92? It was public charities. Okay. So subsection 2, what does it say? Save as provided by Religious Endowments Act. I think all of you must be knowing, religious places of worship. They have certain endowments and the trusts of those religious institutions, or rather religious trusts, come under the Endowments Act. Okay. Save as provided by the Religious Endowment Act of 1863 or by any corresponding law in force. The territories which immediately before 1st November 1956 were comprised in Part B states. No suit immediately before the 1st of November 1956. No suit claiming any of the reliefs specified in subsection 1 shall be instituted in respect of any trust as is therein referred to, except in conformity with the provisions of that subsection. See, irrespective of whether the trusts which were in existence, okay, before 1956. 1956 is when you have the Hindu law, which has come into existence, right? So, which came into effect rather, okay? So, before 1956, whatever are the claims which were there against the trust, they cannot be claimed under subsection 1. Remember, subsection 1 is for appointing trustee, removing trustee, book of accounts and all those things which we already read. Am I right? So it cannot be filed at this juncture. Subsection number 3. The court may alter the original purpose of an express or constructive trust created for public purposes of a charitable or religious nature and allow the property or income of such trust to be applied cypress in one or more of the following circumstances. So there is a very clear instruction as to what will the the funds of the public charity trust or the public religious trust, how will it be expended? How will the expenses be done? Okay, number 1. Where the original purposes of the trust in whole or in part have been, as far as may be fulfilled or cannot be carried out at all, or cannot be carried out according to the directions given in the instrument, where there is no such instrument according to the spirit of the trust. That means what? These are all certain circumstances. What is the circumstance? First one, where the original intention of the trust, okay, either wholly or partly, has ceased to exist. It cannot be fulfilled at all. Or what's the second one? It cannot be carried out at all or cannot be carried out according to the directions of the trust. See, when we are forming a trust, we will have our aims and objectives in place. Am I right? So aims and objectives, when we are writing the trust deed, we write all these things. But if what has been written in the trust cannot be carried out, it cannot be fulfilled either in part or in whole. Okay. Number C, where the property available by virtue of the trust and other property can be more effectively used in conjunction with, and to that end can suitably be made applicable to any other purposes. If the property, which is the trust property, instead of being used for the purpose of trust, if it can be used for some other purpose. Then D, where the original purpose in whole or in part were laid down by reference to an area which then was but has ceased to be a unit for such purposes. Say for example, here when we are talking about the area in the sense, it is not the territorial area that we are talking about. It is about a particular topic or particular activity, service area activity. Okay. Or where the original purpose in whole or in part have, since they were laid down, been adequately provided for by other means, or ceased as being useless or harmful to the community, or ceased to be in law charitable, or seized in any other way to provide a suitable and effective method of using the property available. Okay, so in all these cases, what happens? The administration, what action will the government take? That is the criteria over here. So what are all the criterias here? The court may, after original purpose of a charitable or religious nature, and allow the property or income to be used for some other purpose. When can the property or income be used for some other purpose other than what it was intended for? You have all this list. Okay, so only if it has been done according to this, any of them, it is not necessary that everything should be covered. Any one of the reasons is there, then the funds or the income, or rather the property of the trust, can be used for any other purposes other than what it was intended to do. Okay. Next we go to section 93, exercise of powers of Advocate General outside Presidency towns. The powers conferred by sections 91 and 92 on the Advocate General may, outside the Presidency towns, be, with the previous sanction of the state government, exercised also by the collector. See, in some of the cases we have already seen that collector will not have the jurisdiction to try. Am I right? We have read it some few sections back. But here what does it say? Whatever is given in section 90 and 91, it includes that. Am I right? So it does not come within the purview of the powers of the collector or powers of the Advocate General of Presidency towns. Okay, you can underline the word, the words Presidency towns for your reference. Then part 6, supplemental proceedings. What do you mean by supplemental proceedings? Okay, section 94, supplemental proceedings. We'll go to what are they. In order to prevent the ends of justice from being defeated by the court, the court may, if it is so prescribed by what? Prescribed by law or from time to time. Okay, issue a warrant to arrest the defendant. See, why is it written as supplemental proceedings? Is because civil court usually doesn't have all these things. Am I right? It doesn't arrest anybody, it doesn't keep anyone in prison. All that purely goes to criminal cases, right? But in certain instances, such supplemental proceedings are necessary. Just like how we have read about appointment of commissions and all, same way supplemental proceedings are necessary even for all these things. So if the situation warrants, then all these can be done by the civil court. That's known as supplemental proceedings. We will come to the list of what are they. A. Issue a warrant to arrest the defendant and bring him before the court to show cause why he should not give security for his appearance, and if he fails to comply with any order for security, commit him to the civil prison. Where have we read this? We have read this in the attachment topic. Am I right? So where the person's property has been attached and he is able to realize the decree holder is able to realize the amount, there is absolutely no problem, right? But where the recovery of money is difficult due to the actions of the defendant, or maybe the defendant is not paying, he doesn't have any property, there is absolutely no way to recover anything from him, then in that case, along with attachment or without attachment and sale, the defendant may be arrested and he can be kept in civil prison for how long? Maximum of 1 month. We have already read that. Am I right? So you should keep, when you are reading something, say CPC, each chapter has a different this thing, right? So each order, each rule, everything is of different chapters, different sections, different subheadings and all that. It is not only CPC. Remember, all the laws have to be read by itself also and book as a whole. Please remember this, okay? So that it will be easy for you to write. When you have to write an essay answer, it becomes very easy for you to write the essay answer. Or when you are being asked some question in Viva, it becomes easy for you because you know how to relate one act with the other. You know how to relate one section with the other. You know how to relate one chapter with the other chapter, right? So it becomes very easy for you because you have understood it on a whole as well as in parts. So it needs a thorough study. So please do it. That's all I can say. Okay. Yeah. B. Direct the defendant to furnish security, to produce any property belonging to him, and to place the same at the disposal of the court, or order the attachment of any property. See, whenever there is an attachment, we have already seen whenever there is a decree, the same cannot be alienated. The property which has been attached, either only for the sake of attachment or attachment at sale, they cannot be sold. It cannot be alienated, and I already explained to you, it cannot be gifted away. There cannot be a release deed to it. There cannot be a partition deed to it. There cannot be a sale agreement to sell. There can be nothing over there, right? So if such a thing happens, if there is a say the defendant is trying to alienate the property in some manner, okay, so in that case also the court can order the defendant to give a security saying that he will not he will keep the property intact for the attachment. Clear? Grant a temporary injunction, and in case of disobedience, commit the person guilty thereof to the civil prison, and order that his property be attached and sold. Where the judgment debtor, okay, either he is trying to alienate the property or he is not, he is trying to run away, abscond from paying the money or whatever it is, whatever is the liability, okay. If he is unable to meet the liability due to some proper reason, then it is okay, he can go to the court and say. But if he is trying to alienate the property, or he is trying to abscond, he is trying to avoid meeting the liability, then what is the third option available to the court? The court can order for temporary injunction. All of you know what is a temporary injunction, am I right? It is a restriction order, correct? Okay, so the court can give a temporary injunction, and in case the disobedience of temporary injunction, you can just mark it there and write it down. Disobedience of temporary injunction, okay, where an order has been given by the court, it has to be followed, am I right? Otherwise it amounts to contempt of court. All of us know that, right? But when a temporary injunction has been disobeyed by the defendant, in that case the court can order for the arrest and detention in civil prison, okay, and also order that the property be attached and sold. D. Appoint a receiver of any property and enforce the performance of his duty by attaching and selling his property. This is a very easy thing, am I right? Appoint a receiver. Who is a receiver? Someone who will look after the administration and accounts of the property which has been attached. Okay, then that receiver will give all the details to the of assets, liabilities, of the expenses, income, everything, and what can be done, how it can be administered, everything will be given by the receiver. Okay, so he will keep a tab of everything and give it to the court. Then E. Make such other interlocutory orders as may appear to the court to be just and convenient. Just like how we do it in the prayer, any other relief or reliefs as the court may deem fit. Same way, here what you have, make such other interlocutory orders as may appear to the court to be just and convenient. Okay, next one, section 95. Compensation for obtaining arrest, attachment or injunction on insufficient grounds. See, this is very important. Underline the words insufficient grounds, because insufficient grounds, when we are talking about this, obviously you will remember about CRPC, IPC, and the criminal cases as well, am I right? Okay, you have it even in criminal cases, correct? Okay, compensation for obtaining arrest, attachment or injunction on insufficient grounds. So wherever the arrest or attachment or the injunction, temporary injunction, these are the three things available to the court, am I right? If they have been done on insufficient grounds, there is no proper proof that the defendant is trying to run away, he is trying to abscond from the liability, right? He is trying to alienate the property. There is no sufficient proof. Just because one party has represented it, the court has passed an order. Of course, It's very, very rare for such things to happen because the court is not so careless. Am I right? But still, sometimes the situation happens in such a manner that, it looks as if sufficient proof is there, but maybe it is not sufficient. In that case, what? It appears to the court that such arrest, attachment, or injunction was applied for on insufficient grounds. If the court finds, okay, if the court feels, rather, not finds, if the court is of the opinion that the arrest or the attachment or the injunction was given on insufficient grounds. See, how will you know? Injunction order is something which is given by the court, am I right? Then how can the court say that it seems to be on insufficient? No, we are thinking of the appellate court here. Okay, so when we are saying, see, arrest, attachment and injunction, these are all the orders of the court. Am I right? It is not someone who is doing it by themselves. So how will the court know that it is on insufficient grounds? How will it decide? It means that the appellate court will decide upon these matters. Okay. B. The suit of the plaintiff fails and it appears to the court that there was no reasonable or probable ground for instituting the same. Okay. Once the judge, of course, none of us know at the very beginning whether it's a good case or a bad case. Only prima facie we can make out, right? So, prima facie it looks to be a good case, but when we come to the evidence, we find that it is not enough. Clear? So, the same thing happens here. The suit of the plaintiff fails and it appears that there is absolutely no reason. There is an unreasonable or there is no probable ground. Probable ground means what? There is no probability of anything which has been submitted in the plaint. Probability of happening of anything which has been submitted in the plaint. Okay, so the plaint gets dismissed automatically. So in such cases also, the compensation can be given. Then the next one, an order determining any such application shall bar any suit for compensation in respect of such arrest, attachment or injunction. Okay, so when an order has already been passed for compensation in the same suit, then it shall bar any suit for compensation. We have the right, am I right? Suit for damages. Damages means compensation. So suit for damages cannot be filed separately for such compensation. Okay, next we go to part 7, which speaks about appeals. Appeals from original decrees. Appeals, what is the original decree? Whenever a suit is instituted in the original court of jurisdiction, court of first instance as we say, right? So court of original jurisdiction or court of first instance, anything you can say. First time when we file a case, that is known as court of first instance. Clear? So that becomes the original decree. Clear? So from there, the decree, the appeal will go on to the next higher court. It is not always that we run to the high court. Am I right? So we go to the higher court. We will see this, save where otherwise expressly provided in the body of this code or by any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decisions of such court. You understand? So court of first instance, above that when we are looking at the hierarchy of courts, we get to know it. Am I right? So court of first instance is one. So whatever is the decree which is passed by the court of first instance, that is known as the original decree. Right? So as per the code, whichever is the next hierarchical court. Okay? Just above, just superior to that. Not superior, just above that. Right? So that becomes the appellate court for that particular original decree. Clear? Then B, that is 2, an appeal may lie from an original decree passed ex parte. See, ex parte, what's an ex parte? Where one of the parties has not attended the court. Not attended the court, has not appeared before the court at all. Either it can be right from the beginning or beginning few days he was there, then he was not there. Usually it is like right from the beginning, even after getting the summons, if the party does not appear. Right? Even after service of summons, if the party does not appear before the court, then the party is placed ex parte. That means what? The case will go on without him. Ex parte, without the party. Clear? So even though the case was held, that is, it was decreed ex parte without the appearance of one of the parties, even then appeal can be filed. No appeal shall lie from a decree passed by the court with the consent of parties. Where there is a compromise, where there is a mediation, negotiation, we read all that, right? So where there is a conciliation, all that. So there is a settlement between the parties. They have voluntarily agreed to do or not to do something. Where they have voluntarily agreed to do or not to do something, then no appeal shall lie in such cases. Why is it? Because it is not thrust on them. It is the voluntary acceptance of the parties to do whatever are the terms and conditions written down in the settlement deed. Therefore, there cannot be any appeal. Fourth point, no appeal shall lie except on a question of law from a decree in any suit of the nature cognizable by the court of small causes, when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. Okay? So, no appeal shall lie except from a decree in any suit of the nature cognizable by court of small causes. If a decree has been passed by court of small causes and that too not exceeding 10,000 rupees, then there can be an appeal. But otherwise, no appeal can be filed except for question of law. So this comes to a different category of court, which is the court of small causes. Clear? Then next, section 97. Appeal from final decree where no appeal from preliminary decree. Where preliminary decree cannot be appealed against, right? Then there can be an appeal from final decree. We have a set of few decrees, interim decrees, am I right? Interim decrees means what? In between, when the case is going on, the case is still pending and a decree is passed. That is known as interim decree. Correct? So certain interim decrees we have a right to appeal. Say for example, temporary injunction, okay, or maybe interim maintenance, something like this. Clear? Bail applications. All these things are all known as, of course, bail applications. I don't want to bring it here. Okay. So in all these things, what happens? The appeal can be filed on an interim decree. But when it comes to certain cases where the interim decree cannot be filed against for appeal, then it can be appealed against on the basis of the final decree. Where any party aggrieved by a preliminary decree passed after the commencement of this code does not appeal from such decree, he shall be precluded from disputing its correctness in any appeal which may be preferred from the final decree. So where there was before the commencement, okay, after the commencement of this act, that is the code, after the commencement of the code, where the party, even though he is aggrieved by the preliminary decree, he does not go on appeal. He says it's okay, we'll see what happens finally. Some of them are like that, am I right? So even though he is aggrieved by the preliminary decree, he waits for the final decree to file an appeal. Then when he files the appeal on the basis of the final decree, at that time he cannot point out to the court saying that, sir, this is the final decree and I am appealing against it. This is what happened in the preliminary decree. Please treat this also in the appeal. Okay, so that cannot be done. Section 98, decision where appeal heard by two or more judges. Where an appeal is heard by a bench of two or more judges, appeal shall be decided in accordance with the opinion of the majority of judges, right? If there are two judges, then there is no question of majority. But if it is more than two, all odd numbers, right? If it is on the basis of odd numbers, then whichever is the majority decision, that shall be taken into account. Okay. Provided that where the bench hearing the appeal is composed of two or other even number of judges belonging to a court consisting of more judges than those constituting the bench, and the judges composing to the bench differ in the opinion on a point of law, they may state the point of law upon which they differ, and the appeal shall then be heard up to that point only by one or more of the other judges, and such point shall be decided according to the opinion of the majority. Underline question of law, underline one or other judges, one of the other judges. Okay, if there is a two bench, okay, and they have decided upon a particular subject matter, okay, in that case there is a say difference of opinion, it happens, right? So in that case it can be heard by a bench which is one person, one judge should be more than the two, right? So one of the other judges, even though probably the bench is constituting five bench and all those things, it doesn't matter, it should be heard by one of the other judges, and that too on the basis of question of law. Okay, then next we nothing in this section shall be deemed to alter or otherwise affect any provisions of the letter patent of any high court. Of course, high court always has the right to sit in appeal, right? So that is not a question at all. Clear? Then next we go to section 98. No decree to be reversed or modified for error or irregularity not affecting merits or jurisdiction. See, where there is a decree which has been passed, okay, but it has been passed by a court of jurisdiction, it has been passed by a court which does not have the necessary jurisdiction. Clear? Or it does not have a jurisdiction, or it is, if it is passed by a court but it does not affect the jurisdiction, okay, or it does not affect the merits of the case, then it will not be. See, for example, if I have to file the case in a particular court hall, okay, similar court halls are there and all of them have equal powers over the same jurisdiction, say for example, okay, and I am filing it before one court, clear, court hall, and I go there, okay, the decree is also passed, but it is not, the decree which is there is not going to affect the jurisdiction or the merits of the case. In that case, the decree passed shall be held to be valid. There is no question of invalidity in that. No decree shall be reversed or substantially varied, nor shall any case be remanded. Remanded means what? Sent back in appeal on account of any misjoinder or non-joinder of parties. See the reasons, okay? You can write 1, 2, 3 over there so that when you are studying for the exams, it becomes easy for you, right? When can it need not be reversed or substantially altered? When? Number 1, where there is a misjoinder or non-joinder of parties. Number 2, cause of action, misjoinder or non-joinder of cause of action, or any, number 2 is misjoinder or non-joinder of causes of action. Number 3, any error, defect or irregularity in the proceedings not affecting the merits of the case or the jurisdiction of the court. If I have to file a case in Bangalore, I go all the way to Bombay and file a case, then it is a matter of jurisdiction, am I right? So the decree which is passed by the Bombay court, even though that is also a district court, Bangalore is also a district court, but still the jurisdiction is not there. Therefore, it can be reversed. But if there is a decree which does not affect the merits of the case or the jurisdiction of the court, then it need not be reversed, okay, or it cannot be altered, need not be altered. Clear? We'll stop with this, we'll continue a little later. Thank you.